Kuala Lumpur, December 22nd, 2025. Outside the High Court, the air is thick, not just with the end-year monsoon humidity, but with the weight of a decision that reaches up to the ceiling of Malaysian power. For months, Malaysian politics has been haunted by a phrase that sounds like conspiracy bait: the Addendum order. A supplementary order that, if enforceable, would change where a disgraced former Prime Minister serves the remainder of his sentence. But on this day, High Court Judge Alice Loke gives a direct answer. The addendum exists in evidence, but it does not work in law. Watching Explaining Malaysia, a video essay project exploring the soul of Malaysia through primary documents. I'm your host, Mr. Kuala Lumpur. If you think this is about one man, you're missing the real story. This is about two forces Malaysians argue about all the time, often when they don't use legal words or even think about whether they're even allowed to discuss it. Constitutional procedure and royal mercy. Not vibes nor whispers. Proper procedure. Let's start with the timeline, because this judgment is basically dependent on the forensic reconstruction of the case. Najib Razak was convicted in 2020 in the SRC case, sentenced to 12 years in prison and fined 210 million ringgit. After appeals failed, he went to Kajang Prison in 2022. Then came the pardon process. The 61st Pardons Board meeting took place on January 29, 2024. After that meeting, the controversial official announcement came. Najib's prison term was reduced to 6 years and the fine reduced to Rm 50 million. But according to Najib, there was a second document as well, a supplementary addendum order, also dated January 29th, saying the remaining sentence should be served under house arrest at home in Kuala Lumpur. At first, the public argument was about whether that addendum even existed. Government figures denied knowledge, letters were sent, no confirmation came back. So Najib filed judicial review, asking the court to force the government to act. And what he asked for matters. He didn't ask the judge to be merciful, he asked for a mandamus. Mandamus is one of the sharpest tools in public law. It means the court compels a public authority to perform a legal duty. Not a favor, a duty. So Najib had to clear a high bar. He had to show that he had a clear legal right to be moved to house arrest, and the government had a clear legal duty to implement the addendum. And comes the constitutional fight. Najib's lawyers argued that mercy is a royal prerogative and that the courts shouldn't interfere. They also tried a technical route, that Article 42 includes pardon, reprieve, and respite, and that this addendum could be treated as a respite, which they said could operate different. And then they made the big move, the move the judge calls a startling proposition. They argued that even if the Pardons Board meeting must happen, the king isn't required to decide inside the meeting, that the decision can effectively be made outside the room. The judge rejects that. If Article 42 requires the Pardons Board to meet in the presence of the king, with the king presiding, then the constitution is not imagining a parallel track where a life-changing decision is made elsewhere, outside the meeting's safeguards. She warns that this approach invites arbitrary decisions and has no legal foundation. But Judge Alice Loke doesn't just do theory, she follows documents. The government produced the petition papers and the minutes of the 61st Pardons Board meeting. These were initially classified as rahasia, then declassified for use in the proceedings, with portions redacted to protect the confidentiality of other prisoners' petitions discussed in the same meeting. And the key factual finding is blunt. The meetings show only one decision was made during the meeting: the reduction of the prison term and fine. There was absolutely no mention of house arrest. That matters because Article 42 is not a mystical aura. It's a process. It's a meeting. It's the written opinion of the Attorney General, the board's advice, and only then a decision. The process is what gives the power legitimacy. So the judge's conclusion on validity is straightforward. Because house arrest was not deliberated at the Pardons Board meeting, the board never had a chance to advise on it, and the addendum was not made in compliance with Article 42. Therefore, it is not valid. She also deals with the argument that Respite bypassed the Pardons Board meeting. The answer is, there's nothing in Article 42 that exempts Reprieve or Respite from the procedure. If it's a clemency power under Article 42, it stays under Article 42 safeguards. Then comes the second reason the case fails, and it's the part that changes the whole conversation from palace drama into legal reality. Even if you want house arrest, the judge says it is not capable of execution because Malaysia has no legal provision that creates a house arrest mechanism like the addendum describes. Najib's side pointed to Section 43 of the Prisons Act, release on license, as a way to implement it. But release on license is discretionary. The Commissioner General decides. The Commissioner General then sets the decision and the conditions. The Commissioner General can recall the prisoner, and the Commissioner General decides the duration. The addendum, by contrast, fixes the duration in advance and removes the discretion and recall power that the statute clearly gives to the prison authority. The judge says it doesn't match. It's at variance with the law. So, with those two failures, invalid under Article 42 and not executable as house arrest under existing law, the result is clean. No valid addendum means the government has no duty to enforce it. And if there's no duty, Mandamus cannot be granted. The application is dismissed. Now, here's the what's next, because this story doesn't end at the High Court doors. Najib's lawyer has decided they will appeal this ruling. And this decision lands in the middle of a big week, arguably a bigger week. Najib is also facing a major verdict in his biggest 1MDB-related trial, scheduled for December 26. If he's convicted, it could add significantly to his prison exposure. So this isn't just one legal loss or one political win. It's Malaysia's system stress testing itself in public in real time. And the biggest takeaway is the one Malaysians rarely get taught explicitly. In a constitutional monarchy, like our country should be, the power isn't only in royal mercy. The power is in the procedure that controls mercy. Because if decisions can be made outside the room, outside the minutes, outside advisory structure, then the structure becomes theatre. But if procedure matters even at the top, then Malaysia is not run on whispers, it's run on solid, concrete, constitutional steps. You've been watching Explaining Malaysia. I'm your host, Mr. Kuala Lumpur. Thanks for digging into the Najib mess with me. This is our last episode for the year, I think. We've taken a bit of a break, but I have a lot that's exciting to tell you. A lot of exciting episodes in the pipeline, and I'm also launching my podcast, Kuala Lumpur the Podcast, an audio-only show that you can catch on Spotify and hopefully all good places that accept podcasts. You can expect more of a frequent release schedule for this. In the meantime, if you enjoyed this video and my explainer on the latest developments of this case, directly based on the judgment from Judge Alice Loke, please like, subscribe, share this video. Let's face 2026 with more optimism about Malaysia as a country. Thank you.